Welcome back to the Fostering Financial Victories podcast. I'm Eric, your host. Thanks for joining us again. Today, I am joined by two attorneys. So I'm in a different seat today. So I am going to just literally try to get out of y'all's way and not mess up your conversation. So Austin, thanks for joining us again. Member of our team, attorney, mom, all types of things that you have going on.
Superwoman, all the good stuff.
Yep. Yeah. Cam Sallé, also an attorney here in Greenville in the real estate world. Yeah. So you guys know each other really well.
Yeah.
You want to kind of give us a little background?
Absolutely. So before I joined Foster Victor Wealth Advisors, I was working with Cam over at Sallé Galloway, and their practice centers around real estate. They do residential and commercial real estate closings, also some estate planning, and some other commercial and contract type work. So Cam's been doing this a long time. And I was over there for about 8 years. So we do know each other well, and he's here to give us some information about how the real estate process works.
All right. So Cam, how in the world did you find yourself in the real estate side of law? Was that always the goal?
No. It's a good question. No, I was not always in the real estate side of law. I started out, I actually have a LLM in tax, which is just an extra year after law school in tax. And that's what I started out doing for a larger firm, and then tax, estate planning, merger acquisition type stuff. And my dad had always had a little real estate brokerage in our area, and I always had a bunch of realtors asking me to do closings, and I always told them no, I didn't want to do it. It seemed really boring, which I realized is ironic coming from a tax attorney.
Yeah, kind of.
But eventually went out on my own and found myself sitting in for another attorney doing a closing, and really enjoyed it.
Just kind of fell into it, so to speak?
I just kind of fell into it, yeah.
So the real estate process, so personally, I've got all kind of questions. I just refinanced my house on Monday of this week, and I think I signed 150 documents, it felt like, and I'm sure my signature got worse as I went. Let's just talk through what are all the details involved for the layperson who is not an attorney and knows all of these structured elements. What are they? What's it for?
Sure. Part of what makes your standard closing have complications, have delays, have issues, is, for one thing, there are many, many parties involved. There may be a listing agent, there may be a buyer's agent, there may be a lender. The lender needs an appraiser. There's a home inspector, there might be a termite inspector. There's a title company, or in our state, an attorney, and then there's the buyers and sellers themselves. So with that many parties, there's always bound to have some wrinkle come up, some issue, some delay, some gap in communication. So a lot of the work that we do and the other parties do is kind of putting all that together, quarterbacking it all, making sure this side's talking to that side. The appraiser's report that comes back from the lender is conveyed to the right parties. Is that appraisal high? Is it low? Any issues that arise? And then, of course, the big issue a lot of times is these days, like in your refinance where there's no other parties involved, it's just underwriting. And that's all kind of done on the lender side, but you never know. You never know how that's going to go.
And Cam, you mentioned in the state that we're in South Carolina, that an attorney handles real estate closings. In other states, you may have a title company. Can you talk a little bit about the two hats that you wear there in our state, and how real estate's the practice of law, that type of thing?
Sure, yeah. In our state, attorneys are the only ones authorized to do closings by state statute. In other jurisdictions, the majority of jurisdictions, it's actually title companies or escrow companies that do a lot of the standard residential closings. In other states, it's attorney only. There's even one or two states where each the buyer and the seller are each required to have their own attorney.
Separate?
Yes. New York is like that.
Not surprised.
Yeah. But whereas a lot of other states, there's no attorney at all. But there are two sides that we wear in South Carolina. There are a lot of title companies, two hats they wear, which is a title insurer agent effectively, which means you're an insurance agent for the title insurance company. Title insurance is just a product that ensures the title's clean. There's no issues. You've got the ownership you think you've got. Or more importantly, from a lender's perspective, that the title's clean and their mortgage is secure as they think it is, which is why lenders always require that. But we have that side, making sure the title's clean, and then we also have the closing side in our state. In other states or other jurisdictions, those may be divided up differently. But there's always those two components.
So it's always state by state with this?
As far as a lot of the rules, customs, and regulations as to who's involved, is both for title insurance and for closings. Yes, it's very much a state by state thing.
Okay. So when the buyer receives their final disclosure that kind of lists out all of the details of the closing with the costs and how much is being financed and how much is being brought to closing and all those things, as it lists out all the fees, I think this is where most people see it and they think, my gosh, what am I paying all this stuff for? What does this give me?
Yeah. Good question. A lot of what you're paying, assuming there's a lender involved, a lot of what you're paying are lender-related fees or third-party related fees associated with the lender. For instance, an appraisal.
Okay.
So, standard underwriting requirement the lenders have is they're going to have to make sure the property appraises for what they're basing the loan off of. So there'll be a fee to the appraiser. There'll be a fee to running the credit report. There'll be a fee for, many of them use different labels, but there's always going to be some kind of underwriting, origination, processing type fees from the lender directly. And then you've got the title side. You got attorneys or escrow companies, whatever they're charging. And you got the title insurance, and then the inspections, whatnot. If you're on the seller side, of course, you have commissions. You have deed stamps or transfer taxes. So everyone's got to get their cut, just like everything else in life.
Right.
Everyone's got to get their cut.
So the price of the house is not really the price of the house until you get all that stuff involved.
That's right.
So, Austin, a couple weeks ago, you hosted a discussion in our office about this exact topic, and that's kind of where this kind of came from. But title insurance was probably your biggest talking point out of all of it, and I think it got the most interaction. And it's one of those fees that's on that closing disclosure. Can you just talk through, and I know you just hit on the title insurance, what exactly type of insurance is this?
Okay. So title insurance, I would say, is the most misunderstood type of insurance there is out there. A lot of people feel like title insurance is there to cover the attorney who did the title search or cover
like
up
errors and
mistakes.
omissions
Right,
kind of thing?
that type of thing. And that's not what title insurance is.
Okay.
So title insurance is ensuring the marketability of title to the property. So it's making sure that the person who is purchasing the property or the lender who's taking an interest in the property are in the highest position possible. They don't have anyone else out there who has a lien that they don't know about, that there's not someone else who could claim an ownership interest in that property, that there aren't things like easements that aren't disclosed and defects on other types of defects on title. There wasn't a probate situation out there that wasn't cleared up, and now it's affecting the ownership of the property. So that's what your title insurance is ensuring. It's an incredibly affordable type of insurance, and it's a one-time cost at the time of closing, or there are other times I guess you could do it if you had a separate appraisal. But it's very important, in my opinion, and the opinion of most attorneys, I would think, that buyers get their title insurance. In many states, I think all but 3 maybe, Cam, it's a requirement for the buyer to purchase title insurance.
Well, you just mentioned that the lenders typically require it.
Oh, it's going to be.
Yeah, any loan, they're going to require it. And it is, and the very fact that they require it tells you how important it is.
Yeah. So, like, I think when most people think about insurance, they think, well, like for example, car insurance. I wreck my car, it's going to pay me the value of the car.
Right.
Does this pay out? How does this pay out?
Absolutely. So you're not likely to have a title claim, and especially in a state like South Carolina where an attorney was required to check title, to look on the county records and make sure that the conveyances throughout history look like they were done properly and like they are passing to the new purchaser free of any encumbrance. But there are things that get misindexed at the county level that the attorney may never see. There are things that no one can know about because they've not come up yet in history. So you're really sort of insuring against unknowns, okay? So when you purchase your title insurance policy, if in the future something comes up, there is another party that comes forward that has some interest in your property. The title insurance company will pay out to protect you as the buyer in your investment in the property, to keep you in that position of we call it.
So is it paying you as the owner, or is it paying the person who comes in and contests it?
It can be many things. It can pay you as an owner if there's a loss of value with regard to your property. It can pay another party to settle a claim on your behalf. It can pay another insurance company. It comes in and it pays to make you whole again.
Got it.
And again, so in South Carolina where we are, and I know we keep referencing that a good bit, and we have viewers who are all over, but the title insurance rates are set by the Department of Insurance. And so they're a one-time fee at the time of closing based on, for the owner, the purchase price, and for the lender, the loan amount. Okay, so you pay one line item on that, and it might be $200 at the time of closing. And if you have a title defect that comes up later that's an insurable defect and it's a $30,000 problem, the title insurance is going to pay that, and you've paid $250 or $200 one time.
Got it. So not to harp on this, Cam, how often do you see this actually pay out?
Fortunately, not too often. It's one of those things. It's like, the way I look at it, it's like any other insurance. You hope you're getting ripped off, right? I mean, when you buy life insurance,
you hope not to use it.
That's right.
You hope you're wasting your money.
Yeah.
Or health insurance, or any other insurance.
Good point.
You hope you never need it.
Yeah.
When I have been involved in 3 or 4 situations where title insurance companies were involved. One of the other big things that I've seen that they pay is they pay attorney's fees.
Mm-hmm.
So often we're talking about something that affects the title, but is not by itself. It may be an invalid claim. Someone may be saying, well, that wasn't my signature. And it was. But it might take $27,000 in attorney's fees to get a judge to say, yeah, that's an invalid signature.
Okay.
So it's very valuable in those instances as well.
Okay. So you often hear when companies are advertising, whether it be a mortgage company or a real estate company, no closing costs on this loan. What does that actually mean based on all the discussion we just had about all these fees that are baked in?
Mm-hmm.
How is that actually done?
Yeah. It's built into the spread.
Okay.
So generally speaking, if a lender is saying no closing costs, if the going rate is 4%, say, on a 30-year, they may charge 4.25%.
Got it.
For that loan. And the lender is going to pay them that spread. Now, that's not necessarily a bad thing. It depends on what you're doing. So
Sure.
if you're only going to be in the house, your plans are to move in 3 years, it's probably a good trade any day. If you to go ahead and pay a little higher interest rate because you're only paying it for a couple of years and it's not that significant, versus if you're going to be there 30 years, you think this is the house you're going to die in,
Sure.
raise your family in, whatnot, then you're probably better off generally paying the closing cost at the time of closing.
And taking the lower interest rate.
Is there anything that that pops up with closings that you can almost bank on as being a surprise to the person across the table? Or what's the most common thing that's a surprise for them?
What I see is sometimes they're surprised by deed stamps or transfer taxes, how much those are, which vary widely by jurisdiction. That can vary greatly. They agreed to pay them in the contract, but they don't have any idea how much they're going to be.
Uh-huh.
Another thing is sometimes there's issues with lenders, but generally the lender fees don't come as a surprise because of all the regulations and all of those disclosures now. it's hard to be too surprised by that. Actually, probably the biggest surprises or things that come up at closing are when there's a disagreement between sellers themselves. So often in a divorce setting, for instance.
Okay.
Well, yeah, the order says I was supposed to get that, but they're not. That was before so-and-so didn't pay the last 2 mortgage payments, these kind of things. You just never know what you're going to see. But those come up. The other big thing that I've seen recently, just as they've increased, are HOA transfer fees, those type of fees. There's a lot of, usually those are determined who's going to pay those by contract, the buyer or the seller. But those can be anywhere from negligible amounts, like $75 to over $1,000. And it's just one of those things that, at the end of the day, when someone's already feels like they've been nickel and dimed and spread thin, and then they're hit with a $1,000 transfer fee. Yeah, it's one of those fees that kind of sets them off.
And I'm going to add to that other things. Those are all things that come up a lot of the time because people don't know all of the pieces that go into a closing. And so they may see certain line items or costs there that they're confused about, or they didn't know that they were paying. And a lot of times most of the time it's very clear in the contract which side was supposed to pay what, but they may not have actually known what each of those individual things are. Another thing that can come up that can really stall a closing, me, going back to that title side, some type of title issue that's come up in the process. So it's pre-closing. This is not something that's insured yet. This is not something that, has been discovered after the new buyer receives the property. It's caught in the process of an attorney or a title officer, depending on what the state is, reviewing the back title to the property. It could be something like a deed missing a signature, and that sort of invalidates that deed or that transfer, and someone needs to go back and help correct that and fix it. It could be something like probate issues come up a lot. We could get almost all the way to closing in any state without knowing that one of the sellers has passed away. Because real estate's kind of a unique situation where whether you're a title officer or an attorney, the contract between the buyer and the seller, who you normally have not met prior to closing, you've done all this work for them in the back end, but you haven't met them prior to closing. Sure. That contract comes to you already signed, having been negotiated with just basically what's supposed to happen at closing, and that allows the attorney or the title company to begin their work to get you and the lender to the table. And sometimes the two parties fail to let you know that, hey, this property, on title that it's owned by mom, dad, and son, but dad passed away, and it's not owned in such a way that it automatically transferred title into the remaining two people. So we find things like that. And when you find an issue with title, you have to stop the process right there and you have to correct it. So if I can give a little plug for real estate attorneys or, title officers, that line item there that is their fee or that is related to the title insurance they're going to issue, there's a lot of work that goes into the background of just getting those two parties to the table and making sure that title's clean.
Yeah, I could see that being an issue. If
someone passed away and no one knew it. Yep.
So would that be the case where, so let's say I'm selling a house and my wife and I signed the contract, everything's ready to go, and then one of us dies in between the signing of the contract and the closing?
Mm-hmm. An attorney or the title officer, whoever's reviewing title, needs to be made aware of that, number one. If you're in a state where the probate process has to have begun before the title can pass to a new party, or if title is held in such a way where that has to happen by law, then someone needs to step in, the attorney usually, and explain, hey, we've got to open a probate file. There's a process to go through with the probate court in this particular jurisdiction, and we've basically got to get permission, kind of depending on what that person's will says, to sell this property out of probate. We have other mechanisms. We may look at the deed and say, no, everything is fine for the transfer of title because title was held in such a way where by law the property is now only in the name of the remaining party. In our state, that's usually joint tenants with rights of survivorship. So there are ways that you can hold property that sort of avoid probate, But there are other ways where you have to stop the process and deal with a problem and make sure you can transfer title cleanly to the next person.
We actually had 3 closings in the last 5-6 weeks where the seller was admitted to ICU between the time they signed the contract and closing. In all of those cases, fortunately, they eventually made it out of the hospital, but we had to scramble.
Kind of wait around.
Get a power of
Yeah.
attorney
Yeah.
signed, had by someone in a hospital with a notary, and you just never know what you're going to see.
Wow.
Right, because to transfer title, the people who own the property, who have legal right to the property, have to sign it over. And in every state, there's a very particular way, whether it have to be in front of witnesses, notary, all of these documents have to be executed a particular way. So if you have someone who's incapacitated even for a short period of time, they're in the hospital and they can't do that, they're not physically available, then we have to start, like Cam was saying, we have to start looking for these other legal methods to be able to handle that closing, like getting a power of attorney, as long as they're able to appropriately execute a power of attorney. So,
Hence why it takes 30 to 45 days to close.
yeah, absolutely.
Got it. Okay. So for the folks who are selling a house themselves without a realtor involved, is there a different experience from your perspective with that?
Mm-hmm.
Do they miss more minor things that could be big things?
Yes, there is definitely a difference. If nothing else, when there's a realtor involved, assuming they're a decent agent, the parties come to the table with realistic expectations.
Okay.
When they sign that contract, they've got realistic expectations, generally. There's exceptions, but generally. They know what they're getting into. A lot of realtors will kind of show them, hey, this is what the sales price is. We subtract this and this out. These are likely to be your costs. Your bottom line should be around X. With for sale by owner situations, I would say it's more common than exceptional that the seller is confused and surprised by something.
Mm-hmm.
Well, wait a second. For instance, a common one, well, wait a second. I signed that saying I'd pay $3,000 of the buyer's closing cost, but I've got another $2,000 of my own closing cost. The agreement was I was just supposed to pay $3,000 in closing costs.
Mm-hmm.
Well, actually, no, the agreement says $3,000 of buyer's closing costs, then you got to pay your own. Things like that.
Okay.
There's definitely a difference in kind of preparedness expectations in a general scenario like that.
And probably communication too. I mean, honestly,
Yeah.
with the attorney's office, especially when you have an agent who does, many of these a month versus a seller or a home buyer who may only do this once in their lifetime,
Sure.
then there's a different level of communication, of knowing what the attorney needs, what information they need. And Cam's 100% right. Understanding that real estate contract, which is it's not a fun read. I mean, it's not something that most of us, like, even us nerdy lawyers don't sit around and like read it on the weekends for fun. It's got a very specific flow to it and tells what the buyer's supposed to do, what the seller's supposed to do, what's required of everybody, and who's going to pay for what. And a lot of people representing themselves just sign this as it's all boilerplate, but that language means something when you get to the closing table.
So that gives me another follow-up question. Of all the forms and documents that get slid across the table, which one should they actually read? Like, should they take time to read these things? Because if they did, it would take 6 hours to do the
That's a
closing.
great question.
Yeah.
'Cause you don't see them beforehand.
Yeah. From the perspective of a closing attorney, you shouldn't be.
That's what I thought.
In all seriousness,
Yeah.
if you're a buyer or a seller, the most significant one to most people is the settlement statement, the
Yeah.
one that has all the numbers.
Right.
Shows what your costs are. If you're a buyer, shows what the bottom line you're bringing. If it's you're a seller, shows the bottom line you're getting. That's something people should look over, and usually that's one that they can look over.
You've
ahead
seen
of
it
time.
beforehand,
Right.
yeah.
So that's one you need to look over. If you're a seller, you look to make sure the commissions are correct, any repairs that are supposed to be on there are on there, etc. If you're a buyer, you're looking to make sure that all the lender fees match what they were quoted, and that all of that looks in line. You're getting credit for your earnest money deposit, that kind of thing. If you're a buyer, the other important document from your perspective is probably the promissory note, which is just has your interest rate and terms on it.
Okay.
What's your monthly payment going to be with your interest rate for what term? That's about it, really, as far as the buyer's concerned, because the rest of it, well, even including some of that, but the rest of it is definitely just to protect the lender in the event you don't pay.
Got it.
That's really what the rest of it boils down to. As a matter of fact, with a cash purchase, the buyer usually signs 3 documents compared to the 100-something.
Oh, yeah, it was a lot.
That's the difference.
It was a bunch.
Yeah. And that's also something that I always kind of took it upon myself, and I know that Cam does. As a closing attorney, when you're handling this for someone, you realize they have not read every line of that. You also realize they want to know what they're signing, and they have a right to. So you develop a concise way to explain to the client, this is what you're signing, this is what the mortgage does, this is your note, and here are the terms. You know, there's some things that you explain to them, because part of your job as the closing attorney is to make sure that they understand what they're signing, and also to make sure that the lender's documents are properly executed and that that loan is closed properly.
Good. Okay. So as we start to wrap this up, Cam, is there maybe there's 2 or 3 things that you would advise for somebody who's coming to a closing, either from the buying or the selling side? What could they do leading up to this to make certain that it's smooth, it's easy, it's not anything that's full of landmines that they just don't know is coming?
Sure. First, one of the things I'll tell you is communication. If something pops up, because there are so many parties, it's important to make sure the parties are notified. Usually if someone has a realtor, that's just them telling their agent. For instance, I'll give you an example. Had one not long ago where the water line going into the laundry room broke literally the morning of the walkthrough. But if we're not told about that and they come to closing, that's going to be an issue.
Sure.
But there's often, for instance, changes in sales price, and there's a contract addendum, and no one forwards that to the lender or the attorney. So you get to closing, huge delay. So I'm just giving you examples, but the moral of the story is communication. Making sure if you're a buyer, the lender knows about anything that changes with your financial status or the house. If you're a seller, any repairs that need to be done are done. That you've got the electricity on when people are going for inspections. It's another common one that people shut off the electricity because they've already moved out. People can't turn on the lights, do an inspection.
Probably be helpful.
Yeah. As far as actually the day of closing, I think if you're a seller, this sounds basic, but people are moving, their stuff's everywhere. Bring an ID.
Yeah.
That sounds really basic, but the fact is we're required to look at that because of all these laws, the Patriot Act, all of that. We're required to have IDs. We want to make sure you're not on you are who you say you are. If you're a seller, we don't want to get sued for sending your proceeds to someone else.
Yeah.
I mean, that sounds pretty important.
Yeah. If you're a buyer, making sure you bring either, depending on your jurisdiction and the escrow company or title company or attorney closing it, either a wire or a certified check for what you need to bring.
I was going to say, Cam, can I write a personal check when I get to your office for all of my closing costs?
Yes.
No,
It needs to be, and if you don't know, if you're a buyer, this happens often, they don't have the final number till the morning of closing. But they're moving from Missouri, where they have a credit union, which doesn't have branches outside of Missouri. Send a wire for a little more. You should have a general idea. Go ahead and send a wire for a little more. That attorney or closing office will refund you that excess at closing. Not a big deal. It is a big deal if you show up at closing at 4 o'clock on a Friday and you haven't started a wire yet, and you're supposed to move in over the weekend. The seller may not let you move in because that wire is not going to be processed.
They
haven't been paid.
Okay. What else? Anything else that you think might be?
So many things.
What else should we talk about?
So many things. But no, Cam hit on the important stuff. I think by and large, escrow companies, title companies, attorneys who conduct closings do a really good job of trying to prepare the client for closing. But just understand that this is a little bit of an oddity in the law where the parties haven't necessarily had a lot of communication with the attorney's office prior to closing. The attorney is communicating almost constantly with the lender, if there's a loan on the property, with the real estate agents, if they are involved, and then if it's a buyer and seller who are unrepresented, as much as they can with those parties. But communication is key in this, and let your attorney know, or whoever's handling the closing, let them know if there are changes. Like Cam said, let them know if there are price and contract changes. Make sure that all the parties who own the property and all of those buying them and on the loan come to closing that day and sign. Yeah. You'd be surprised how many times someone just didn't think they had to come, and it holds up a closing. And then when there are snags in the process, whether it be on the lender's end because an appraisal didn't come in the way that it was expected, or an underwriting condition hasn't been met, or if it's on the attorney side, meaning that there is something that showed up on title work and something's got to be corrected, understanding that the contracts do have timing mechanisms in there to allot for those things. And I know that you and your family want to move, but there is a process to make sure that it gets done properly so that you don't have problems in the future. So just kind of being understanding of that process, I think, is a big deal.
Awesome. Well, Cam, I want to give you a few minutes to tell everybody how they can find you if they want to reach out and ask you questions or use your team for what you guys specialize in. So go right ahead.
Yeah, probably the easiest way is just to go to our website, which is SalléGalloway.com. That's a weird one. SalléGalloway.com. One of these days we'll get a shorter one.
Abbreviate it, maybe.
Yeah, I know. We really should. And that's probably the easiest way, which has all of our other contact information. Of course, we're on Facebook, social media stuff as well. And we can ever help you, let us know. Don't hesitate.
And if you're a client of ours and you have questions about the real estate process, or, other legal type questions, you can always get in touch with me. And if you need a referral to a good real estate attorney, I know some, and I can make that referral as well and give you that information.
Awesome. Well, Cam, I'm not going to let you off the hook just yet. There are 2 questions that we ask everyone who joins us. Austin has already gotten blindsided with this one time, so I'm not going to ask her again.
Thank you.
The first question is, if you could buy anything in the world, regardless of what it cost, what would it be? This is straight putting you on the spot.
I could buy anything in the world, regardless of what it costs.
You have a really nice wife and a big family, so
yeah. I'm thinking I'd buy some alone time.
Man, I didn't know that's where that was going.
Just kidding.
She sets you up.
I think I'd like a nice house, with some space on an island.
On an island?
Yeah, but not an island too remote, with an airplane strip, so I can get back and forth.
Okay.
Yeah.
I like that.
I like that.
All right, so second question, last 2 things you actually spent money on.
Last 2 things. A electronic wireless headset for my son's Xbox for his birthday yesterday afternoon, and coffee. That's it. Boring.
Crazy lawyers.
Not bad. You at least had something in there that wasn't, like diapers or
That's
something.
right.
Yeah,
That's
that's what we all spend money on.
That's right. $99 on Xbox.
Oh, God. Yeah, and that's just the start.
Yeah, that's just
It's just the headset. Okay. Well, thank you guys for joining us.
Yeah, absolutely. Thanks for having
If you have questions or suggestions on topics that you would like for us to cover, you can reach out to us on our website at fostervictorwa.com. You can also follow us on Instagram. We post a lot of random updates from our firm, but also on different topics throughout the course of the week. It's Foster Victor Wealth Advisors. Please share this, subscribe, send this to somebody who you think might find it interesting, and we appreciate it. See you next time.
Thanks.
Information contained in this podcast was intended for general use, not to be used as specific advice. For content tailored to your personal situation, please contact one of our wealth coaches.